haters.
Hello everybody, you are gonna have to bear with me because I am so sick. I am meant to be at work right now. I've had to take the whole week off because I have a nasty chest infection. I have wanted to bring this news to you guys all week, but it's only now that I've been excuse me, being able to actually be in a position where I can actually talk without coughing too much. So please bear with me and sorry for the coughing. Hello, everybody in the chat. We've got Selena here, Catherine Olsen, Philip, Vault Digger. Thank you for joining. Like I said, I'm going to be coughing a lot, but I'm going to try and make my way through this because I think this is important news. I have won a semi kind of legal case with regard to East Grinstead Town Council and their censorship of Scientology-based questions at a council meeting. Now, to give everyone a little bit of a rundown, hey, Jeremy, how's it going? Thanks for joining. To give everyone a little bit of a rundown, in January, 8th of January and the 29th of January, East Grinstead Town Council, which is the town in which Scientology have their UK headquarters, there were two public council meetings where questions were raised by members of the public about the council's close association with the Church of Scientology. The 8th of January, sorry, that was recorded and uploaded to my YouTube channel because it's in the public interest. However, the second meeting on the 29th of January is something that East Grinstead Town Council have been trying to hold on to. They've published a redacted version. They censored the minutes of the meeting and they blocked out the entire public questions section. I then had a complaints hearing where they decided that it wasn't right that the whole public questions section should be redacted. And so they uncensored it, but they did censor some specific questions because they claim they contained allegations against the Church of Scientology. Now, I took this a little bit further because I submitted a Freedom of Information Act request to try and get a hold of the entire minutes and the recording and a few other things as well in the public interest, because here the members of the public are asking the council very valid questions about their relationship with one of the most controversial groups on planet Earth, and they are sharing their concerns. And then the council have done everything they can to try and withhold publishing that information. So my Freedom of Information Act request was denied because the council said that I was a vexatious bully. They said that because I had submitted 4 Freedom of Information Act requests in a 3-month period, that I was doing so only to harass the council, to overwhelm them, and that there wasn't therefore a legitimate public interest. So the Information Commissioner's Office, which is the regulator here in the UK that looks after data, information, freedom of information, data protection, that sort of thing, did a 5-month-long investigation. And on the 21st of August, 2 days ago, they issued a decision ruling in my favor. So we're going to read through this decision notice together. Here it is. Excuse me, I have my honey and lemon, so bear with me. Public Authority East Grinstead Town Council decision. The complainant, which is me, requested information from East Grinstead Town Council, the council, relating to questions asked at a council meeting. The Commissioner's decision is that the Council is not entitled to rely on Section 14.1. So Section 14.1 in the Freedom of Information Act, there are certain circumstances in which a public authority can reject or deny an FOI request. And Section 14.1 is vexatious. So if there is some guy or female for that matter, submitting hundreds of FOI requests just because they know it's going to overwhelm the council, and they're not actually trying to get any information for any real purpose. They're just trying to overwhelm and annoy the council. The council can deny the FOI request based on the fact that it's being done with ill intent. So that's what section 14.1 is. And what they're saying here is that the council is not entitled to use that section of Freedom of Information Act to refuse to comply with the request. The commissioner requires the council to take the following steps to ensure compliance with the legislation. The council must issue a fresh response to the request which does not rely on section 14.1 of the FOIA. The council must take these steps within 30 calendar days of the date of this decision notice. Failure to comply may result in the commissioner making written certification of this fact to the High Court pursuant to section 54 of the Act and may be dealt with as contempt of court. So, make no mistake, East Grinstead Town Council are now legally obligated to supply this information 5 months after I originally requested it, or it will be dealt with by the High Court, and they have 30 days in which to do so. So let's look through this. Request and response. On the 1st of February, the complainant, that's me, wrote to the council and requested information in the following terms. So the minutes of the council meeting on the 29th of January 2024 contained no record of the questions asked or the answers given during the public question time. The meeting was recorded on Zoom, but that has been redacted also with the public question time removed from East Grinstead Town Council's YouTube page. Please could you provide any and all records of the questions asked and the answers given, including the video recording of the public questions segment of the council meeting held on 29th of January. Now, you may have a slight question on this because the video has since been re-uploaded to the council website, the council YouTube, after my complaint. However, it was redacted because it contained several questions asked by ex-Scientologists where they talk about their experience and they say, this happened to me at St. Hill and this is why I'm concerned about it. And those things were taken out because East Grinstead Town Council didn't want to publish something that they felt could put them in jeopardy of publishing some sort of legal allegation or something that could hold them responsible for libel or slander or whatever. So this request is for any and all recordings, which means unredacted. So that's why this is a key difference, because they now have to supply the unredacted videos and the unredacted minutes of this meeting. Jeremy here, Alex takes no prisoners with these nefarious power puppeteers. Exactly. I really don't I really mean it when I say that I'm not messing around. I'm like a dog with a bone with these things. If you're going to redact the public record and if you're going to censor questions about the Church of Scientology and that's against the law, I'm going to keep going until I get what I want. And what I want is the public record of the questions raised at the public meeting, which I think is quite fair enough, to be honest, in my opinion. Now, this is the bit where it starts to get a little bit more interesting, where we'll get some more information we haven't seen before. Because I said, please also supply any and all internal emails and or written communications, call logs, and meeting records or minutes in relation to the questions raised at this meeting that have been held internally or with other internal and external parties. So this means that if the council have had any correspondence with the Church of Scientology in relation to these questions being raised at this council meeting, they are now going to have to hand over all records of those communications. Now, I don't know for a fact whether there has been any direct correspondence between the council and Scientology in relation to these questions, but Scientology's Office of Special Affairs were present at these meetings, and I'm sure they would have had a lot to say to the council about how to respond to these allegations. For example, by labeling me a vexatious bully and attacking the attacker, which is textbook OSA policy. So if there was any correspondence, we are now going to see whether there was and what it contains. And we have 30 days to wait until we will receive that information. And that's why this is, I think, particularly interesting. The council responded on the 16th of February and refused to comply with the request, citing section 14.1, vexatious request of the FOI, and its basis for doing so. The reasoning covers whether the council is entitled to do so, blah, blah, blah. Now, this is the complainant's position, so that's me. The complainant does not consider the request to be vexatious. In their complaint to the Commissioner, they stated that whilst they have previously made requests for information to the Council, the requests were made in the public interest and were not made in an attempt to disrupt or overwhelm the Council. The complainant believes they have been polite and courteous when corresponding with the Council. The complainant considers the request in this case to be in the public interest as it relates to questions asked at a public council meeting. They stated that other members of the public have raised concerns on social media about how the council has responded to the questions. The complainant believes that by refusing to comply with the request, the council is not being accountable or transparent. I'm glad the Information Commissioner understood what I was saying there, because I couldn't be more clearer. By redacting the public record, you are escaping accountability and transparency, and that's why this is so important. And I'm so glad that the ICO have put this in the decision. Now, let's look at the council's position. The council considers the request to be vexatious. In its submissions to the Commissioner, the Council stated that the complainant is pursuing an extensive campaign against the Council, frequently raising their concerns via social media. The Council provided the Commissioner with a number of screenshots of the complainant's social media posts and links to the complainant's YouTube videos to evidence this. Now, this is why I would be really surprised if there was no correspondence between the Council and Scientology, because this is textbook OSA operation. The Office of Special Affairs use this tactic. When they're being attacked, it's turn it around and make the attacker the attacked, right? The whole thing is, we're not the ones in the wrong. He's the one in the wrong. Look at what he's doing. He's doing this and he's doing this, right? To try and shift the narrative. And by using terms like a campaign, that indicates to me Scientology's involvement. Obviously, I may be wrong, but still. The council stated that the complainant writes articles for websites, including their own website, where they raise concerns about the council. It provided the Commissioner with examples of the complainant's articles to evidence this. Furthermore, the council reported that the complainant sells merchandise containing caricatures of its former mayor on their website, which it evidenced by supplying Commissioner with screenshots of the merchandise. Now, I have something to say on this, but I'll wait till we get to the end of this little section first, because this merch is no longer available on my website. Excuse me. The council considers the complainant to have sent an unjustified amount of correspondence, which has placed a burden on its resources. It argues that the complainant's correspondence is having a detrimental impact on the council, as it is creating additional work for council officers. The council also said that the complainant's correspondence is having a significant impact on the well-being of council staff and council members. Now, in summary, the council is saying that my 4 FOI requests has overwhelmed them, and my several polite emails asking for information about this has overwhelmed them. It's too much for them to handle. They're a council, right? They should be prepared to deal with members of the public requesting information about things that were said at a public council meeting, right? If they had just supplied the information, I wouldn't have had to email them again. They are creating the workload themselves, and this is why it's now had to go to the ICO, and we are still talking about it 5 months later. Let's not forget that this all started with me emailing the mayor back in November, asking whether he thought it was the best idea to be going to Scientology events when there are so many stories of abuse that go on in that organization and on that property, and requesting a meeting with the mayor and the other councillors so I can educate them on what's going on at St. Hill. It all started off very politely, trying to educate them, trying to help them. It's not a planned campaign whatsoever, and it would have all been dealt with very swiftly and promptly if they'd have just given the recording and the minutes of the meeting that was held. It's simple. Hello, Terry Ray. Thank you for joining. I'm behind, but want to say I'm so proud of you. Thank you, Terry. And thank you for your continued support. Jeremy is also saying here, it's also great that you have support in legally binding writing for your effort. Yes, absolutely. And it carries on. Let's carry on with it. The commissioner's position. The question for the commissioner here is whether the complainant's request has the potential to cause a disproportionate or unjustified level or disruption, irritation, or distress to the council. In reaching its conclusion on this question, the Commissioner has taken into account the reasoning of the Council, which in summary is that the complainant has pursued a campaign relating to the Council beyond a reasonable level, including that some of their actions have been inappropriate. The complainant argues that their request does have value and serious purpose. Having reviewed the evidence provided by the council, the commissioner considers that some of the complainant's behaviour appears to have been calculated to harass and offend people involved with the council. This includes merchandise that depicts individuals involved with the council. This reduces the value of the serious cause the complainant may be pursuing. Now, I issued a public apology on my website, Scientologybusiness.com, and I will reiterate it here again. I apologize if by selling for, let me start that again. I apologize if I upset or offended or otherwise damaged the well-being of anyone working for the council, whether that be the clerk or the councillors or any of the admin assistants, by selling merchandise on my store that took fun of the council. It was meant to be a joke. I thought it was funny, as did most, if not all, of my YouTube subscribers and social media followers. However, I understand that perhaps was not the best placed joke, and it was clearly not received in the way that it was intended. So I apologize, and I understand that it may have caused upset. That was not my intention, and I am sorry for that. However, I would also like to make it really, really clear that in all of this, I have tried to approach this with courtesy, with calmness, with kindness, and with people's well-being in mind. Compassion and kindness is how I lead my activism. And there has been none of that from the council side. There has been no regard whatsoever for the well-being or the mental health of the survivors and victims of abuse at St. Hill during this process. Some victims spoke up at this council meeting and said, hey, this happened to me at St. Hill and I'm concerned. What are you doing about it as a council? How are you safeguarding and protecting adults and young people who are vulnerable from abuse in your own town? Perfectly valid question. It happened to me. What are you doing to stop it happening to others? The council's response was to tell them to shut up, stop talking about it on social media, not to ask any more questions, and then to label me a bully. I personally think the council are the ones here in the wrong, and we deserve an apology from the council for the damage that it has done to the well-being of us survivors of trauma and abuse. So, yes, I apologize for selling merchandise that I thought was funny, clearly didn't get received in that way. But I also want the council to reflect on its behavior, and I hope to God, if there is one, that they take this into account and we do one day see an apology, especially in light of this decision from the ICO. I also love that the ICO said here, this reduces the value of the serious cause the complainant may be pursuing. So that means that the ICO recognizes the debate on Scientology and the activism that I've been doing as a serious cause. Now that, I think, is key. This is a government agency. It's an independent regulator, but it's appointed by government and it's accountable to government, right? These are serious people here. The information commissioner here is assessing my activism, and those of you who are supporting me in it and joining me on the streets protesting, everyone in this movement, right? Your activism just as much as it is mine. The information commissioner here is saying that this is a very serious cause, which I think is an excellent acknowledgement of the work that we are doing. Let's carry on. However, the Commissioner considers the request in this case to have a serious purpose and value, as the complainant has asked for information relating to a public meeting and the questions asked during that meeting. This information is of a legitimate public interest. Now, I think that's key as well, because one of the other things that a council can use to reject a Freedom of Information Act request, other than saying it's vexatious, is saying that there's no public interest. So the ICO here are saying that they can't use that as an excuse either, because there is a public interest. So big up ICO. Thank you. Furthermore, whilst the Commissioner is mindful that the Council is a small public authority with limited resources, it appears to him that complying with the request would not be overly burdensome for the Council. The Commissioner also notes that the Council has referred to the complainant having made 4 information requests prior to the request in question. The Commissioner does not believe that this number of requests in itself represents a significant burden. So the Information Commissioner here is saying the Council are making a big to-do about nothing. The guy submitted 4 FOI requests. You fulfilled 3 of them. You can fulfill another one, and it's not too much work. It's quite a simple request. So stop complaining and get on with it, is essentially what the Information Commissioner is saying. Marla is saying, very good. Thank you. Thank you. Dono Harm here is saying, seems like you have a bigger fight with East Grinstead Council than the Church of Scientology. Ridiculous. No, it's not quite like that. Actually, I've spent more time fighting the Church of Scientology than I have East Grinstead Town Council. This matter was pretty much closed in May after my complaints hearing, and the Information Commissioner's Office have been about their business doing their investigation. I haven't really had much correspondence with East Grinstead Town Council since May. It's only when this decision came out that I've now done a video about it and an article. So absolutely, Scientology are the goal here. Excuse me. Bears Mum, I see your comment here, and no, it's not Catherine that he was talking about. It's a different thing, a different moderator, and we're not going to get into that today. I'm sick, and this video has a very specific purpose, which is to talk about the ICO. Okay, let's carry on. The Commissioner understands why the Council went down the route of considering Section 14.1, meaning vexatious request, in relation to this request, given some of the complainant's behaviour towards it. However, the Commissioner's conclusion is that the information request in question does not meet the threshold for him to conclude that it was vexatious. Therefore, the Commissioner's decision is that the Council was not entitled to rely on Section 14.1a of the FOIA to refuse to comply with the request. At paragraph 3 above, the Council is now required to provide a fresh response to the request that does not rely on Section 14.1. It then goes on to say that either party have a right to appeal this decision at a tribunal, and there's a certain amount of notice that needs to be given and how to contact the person to do so. But essentially, the Council now have 30 days to supply the information that I've requested, or it'll go to the High Court and the Council will be in trouble for contempt of court. So personally, I think this is a fairly major victory. It's a minor case in terms of it's not against Scientology. It's about freedom of speech. It's about independent journalism. But nonetheless, this is a legal victory that puts a strong stand, that makes a strong stand against saying, hey, you can't censor the public record. And if you are faced with challenging questions about the Church of Scientology, perhaps censoring them for the public record is not exactly the best idea. And this just demonstrates that if you follow stuff through and you put the work in, you can achieve some victories. So that's where we're at, guys. I am horrifically sick. I have had to take a whole week off work, so I am not going to be at work for the next couple of days, I don't think. So any coffees or PayPal donations that you guys can give would be greatly appreciated, because I generally work in the summer more than the rest of the year, and so there's a lot of lost income there. So any support that you guys can give would be greatly appreciated. I'm going to carry on drinking my honey and lemon and try and get a little bit better before I come back on live. But I wanted to bring this information to you. The Information Commissioner has ruled in our favour, finally. And I will, of course, bring more updates to you as and when I can. One other piece of small news is the bookathon. If you look on my community page on my YouTube channel, Apostate Alex, you will see that Scientology are going to start a bookathon, which is like a big sales competition around the world. So any streamers or protesters out there in the next few days, now is your opportunity. You are going to see more Scientologists on the street with their stress test booths selling Dianetics than you normally would, because a bookathon is considered an all hands, where people from across the org are encouraged to go out and sell books on the streets of whatever city they're in. Because they compete with each other at an international level. So this bookathon usually runs for a week. And so if you're streaming, you're protesting over the next week, I would encourage you to go out and find their book selling booths. One thing to bear in mind from my experience as a bookseller in London is we officially had to have permission from the council to sell stuff on the streets. You had to apply for a street trading license, and quite often, in fact, almost always, we would go out and do these street trades without the required permissions. We would set up a stress testing booth, we would sell Dianetics, and when the council found us and told us off and said, hey, you can't be selling stuff on the streets here without a license, we would just pack down and we would move on to a different location. So if you guys see people out there doing stress tests and selling books, just go and check, report it to the council or the local authority and see if they've actually got permission to sell on the streets, because I think you'll find 9 times out of 10 they don't, and you can get these stress test booths shut down. So that's it from me, guys. Please consider supporting the channel. Buy me a coffee. There's a link down below. Any little bit of donation that you can give would be greatly appreciated, especially right now. Thank you so much. And if there's anything else that you guys need or want, leave it in the comments down below, and I'll do another live stream as soon as I'm better. But as always, I'm on war footing and I'm not fucking about. Bye for now.